To get a deeper understanding of governments, policies, and societal issues, we are here to present about how laws are important for maintaining such regulation of behavior in an individual. Before getting into the subject, the famous philosopher named Thomas Hobbes, in his book Leviathan, discussed that in the state of nature, man always revolt against the weaker personality. Everywhere, man is at conflict with one another. He tries to motivate to escape this chaotic nature of state by creating a social contract. Thus, through the social contract, he was able to prevent the loss of life and emphasize a strong government and social order, which resulted due to the lack of security and protection. So, a topic of discussion of why laws are significant is mainly to resolve the conflicts, to create a framework of interaction between the society and the governmental institutions, and further to eliminate or prevent the chaos, and finally to create a fair and just environment. The sun is shining bright, so does your days. In today's video, we are going to present about the relationship between the psychiatry and the legislation. Yes, today's video is regarding the Mental Health Care Act and the laws related to such issues. Milton Friedman opines, one of the great mistakes is to judge policies and programs by their intentions rather than their results. So, what makes the Mental Health Act 2017 a milestone in mental health care? Let's dive deep. Before entering, there is a lot of anguish about the Mental Health Care Act. This is because of three reasons. Firstly, the lawmakers did not trust psychiatrists in drafting of the act. The second reason is the Indian Psychiatric Society (IPS) was not taken on board, unlike in cases like Mental Health Care Act of 1987. And third reason is the caregivers' rights and burden of care are not adequately addressed. The Mental Health Care Act is a reality that needs to be accepted and the way we need to adopt and comply with the new act. So, before going into this, the United Nations Convention on the Rights of Persons with Disabilities 2006 defines the rights of persons with disabilities and obligations of state towards the persons with disabilities, and signatories mandated to provide the following rights to the person with disabilities. The first is the right to accessibility, including the information technology. Recently, the Supreme Court has provided this Self-Determination Act empowering the rights of persons with disabilities in the ruling done on April 2025. And the second signatory right mandated under rights of rights of United Nations are the right to live independently and to be included in the community. Regarding this right, when we talk about the right to live independently and included in the community, the present day scenario turns around recognizing the rights of persons placed under LGBT plus Q communities. So, Mental Health Care Act also deals with the mental issues regarding LGBT plus Q communities. And the third signatory right is the right to personal mobility, habitation, and rehabilitation. And finally, the right to participate in political, public life, cultural, recreation, and sports. The convention mandates awareness about the human rights of persons and ensures access to roads, buildings, and information. The 8 governing principles that were placed under the convention are respect for inherent dignity, non-discrimination, effective participation and inclusion, respect for difference and acceptance of persons, equality of opportunity, accessibility, equality between men and women, and respect for evolving capacities of children with disabilities. There is a stigma attached to the mental ill admitted in the mental health establishment, and the Mental Health Act of 1987 could not specify any defined role for the appropriate governments in mental health care delivery. To address these issues, Government of India, as a participant in United Nations Convention of Rights of Persons with Disabilities, had two choices in front of it: either to amend MHA 1987 and or to draft a new bill entirely the way to govern mental health care delivered in the country. The Ministry of Health and Family Welfare chose the later part, that is, draft a new bill in entirety. The Mental Health Care Act of 1987, conceived and drafted by Indian Psychiatric Society. However, on amending this act, this was not considered on board. So it raised concerns. It represents the Indian Psychiatric Society raised concerns about various provisions in the new act. Unfortunately, it did not receive any attention. The Ministry of Health and Family Welfare, best known to be entrusted the job of drafting and conducting initial consultation process to psychiatrists, was not a member of IBS. This act was primarily driven by human rights activists and non-governmental organizations with little involvement from professions who are major stakeholders in the delivery of Mental Health Care Act. The persons suffering with mental illness are afforded a lot of freedom and right over choosing the type of medical treatment. An attempt to commit suicide is not a crime, but a cry for help. MHCA 2017 decriminalized suicide. The person who attempts suicide shall be presumed to be suffering from mental stress or illness at the time of act and will not be punished under Indian Penal Code. This will give a long way in decreasing the legal and procedural burden on already traumatized family of person who is attempted suicide. It also mandates the government and private insurance companies to provide a mental health insurance on par with physical illness. Ayushman Bharat has been a landmark initiative from the government of India. The Act also mandates and clearly defines the duties of government. They are also entitled to receive free legal aid when it comes to any legal disputes from exercising the rights accorded to them by the Act. The role of IPS and MHCA played a landmark in giving judgment that repealed Section 377 of IPC, but Nariman quoted that the non-discriminatory clauses of MHCA and also commented against the conversion therapy. There are challenges in this act also. The first is absence of clear guidelines from the Ministry of Health and Family Welfare regarding the mental health capacity. And second is there was a stigma and discrimination regarding the access to the care they require. And finally, the resource allocation stress that should be in compliance with the growing population needs. To protect oneself from the legal hassles and the potential litigation, there is a need to have an extensive document at every step, written and informed from every management plan, and every care provided should be documented to reduce the potential liability and avoid the urge to make a definitive diagnosis in the first visit itself. The mental health professionals need to be consistently updated and maintain competence by attending relevant continuing medical education. MHCA 2017 comes out to be a praiseworthy effort for addressing the long-standing problems encountered by the patients and clinicians in the sector of mental health. It has the potential to bring a radical change in the way mental health care is provided in our country. Perhaps with the future amendments in some necessary areas, this could prove to be a blessing in the mental health care system. The Telemanas Helpline provides free 24/7 telecounseling, psychiatric consultation, and urgent care services. It is also available in 20 Indian languages. The healthcare under Ayushman Bharat Yojana provide free mental health care services at primary levels. So, Government of India is also actively involving in securing the mental health by providing primary consultation through teleservices to ensure the dignity and proper care for people suffering from mental health illness. The Mental Health Care Act is a landmark tool. Thank you. Have a nice day.